My name is Mark Larson. I'm the Chief Criminal Deputy for the King County Prosecutor's Office, and I want to talk about a particular case and issue that is at work in our office right now. Brandon Olabar was convicted of robbery in 2004. He was sentenced to just under 17 years in prison for his participation in what was really a brutal attack. The crime wasn't particularly noteworthy, but nonetheless, it was serious. The victim in the case had been a part of a bad breakup with a girlfriend. The girlfriend felt jilted and cooked up a scheme to go back and attack her former boyfriend. To do that, she enlisted a variety of friends and some family members. They returned to his home. When they got there, they broke into the house. He was pistol whipped, he was beaten, property was stolen from him, and then people departed. As you might imagine, the defendant or the victim was able to identify the girlfriend as having been involved, and he also identified some other people as well. He was shown a photograph array, 6 photographs, and asked to make an identification of one of the particular suspects. The police had put this person in the lineup because he was the brother of the girlfriend and because he was recently out of prison. And they had reason to think that this person might be motivated to be involved in this attack with his sister on the former boyfriend. From that photo array, Brandon Olabar became identified as being associated with and a part of and ultimately guilty of the crime of robbery. The case went to trial, he was convicted, and as I said, he was sentenced to almost 17 years in prison. 10 years into his sentence, working with local lawyers from the Innocence Project Northwest, they approached our office and asked us to reevaluate the case. What they presented at that time was a series of 5 affidavits from a group of men, each of whom said that in fact they were present, that they had participated in the robbery on the victim along with the girlfriend, and that Brandon Olabar was not involved. You know, whodunit cases are significant in the criminal justice system. I think in the popular view is that's really the bread and butter of what we do in the criminal justice system. We solve these whodunit cases. The truth is really quite different than that. Most of the cases we prosecute really involve issues around the degree of harm that may have been committed, the degree of crime that might be assigned to a particular act, or whether or not somebody's drug or alcohol consumption or mental illness may have affected their culpability in some way. The true whodunit is relatively infrequent in the system. And yet at the same time, we know these are tremendously important cases. They are important for a variety of reasons, but none less than this, because the consequence of being right or wrong is so great. In a true whodunit case, if you fail to convict the person who's responsible, they can walk away and never be held accountable. On the other hand, if somebody is convicted wrongfully, you're convicting somebody who has absolutely no connection to that crime whatsoever, and it's really a remarkable and profound tragedy. You know, really since the late 1990s, this country has been looking very, very closely at exoneration cases. These are cases that have come to our attention because they are people who were convicted by juries, and ultimately they were exonerated, typically by forensic science. And now we are up to several hundred cases that we can look at in the United States and understand those, the what happened. To the extent that these were some error happened, what sort of error happened and what's happened. What we've learned predominantly out of those cases is this, that in 70% of those cases, at least a significant part of the evidence that caused a wrongful conviction involved honest but mistaken eyewitness identification. The national debate about these exoneration cases has gone in a variety of directions. Certainly there are people who I think irresponsibly say that these cases really indict the entire system, that the efficacy or the reliability of the criminal justice system is really at stake in this group of cases. There are other people who I think irresponsibly say that these cases are simply outliers, that there's nothing to be learned from them, and that they don't really reflect kind of the business of our criminal courts on a day in and day out basis. What I can tell you is that in the King County Prosecutor's Office, we've taken a different view. Our view is that there is no acceptable error rate when it comes to the criminal justice system, and that anything we can learn or that we can do to sort of improve our accuracy and the reliability of the cases and the evidence that we bring forward is vital for us to do so, and that there are valuable lessons to be learned from these exoneration cases. There's also good news on the front of these exoneration cases, and that is that they appear to have tapered off fairly dramatically after the year about 2000. And I think there's a variety of reasons for that. In part, it's because I believe we have more evidence in our cases than we've had historically. And if you think about the rise of technology and forensic sciences, that makes sense. For instance, DNA, which really sort of beat the original trail into exoneration cases, has really continued in a variety of ways. It's not simply whether we have DNA evidence or not, but we now have an ability to glean DNA evidence from smaller and smaller and smaller amounts of evidence, to the point now where we can get DNA from a touch, from a human touch of a finger. We can obtain DNA in some circumstances. It is also true that the power of that evidence in terms of being able to discriminate between individuals becomes more and more robust. That alone, being brought into our cases routinely as we prepare them and bring them to trial, is significant. But that's not all that we have. If you think about phones, phone tracking, GPS, we can do more now to figure out and locate where people and suspects and victims and witnesses were through phone records than was ever possible in the past. Computer records and other sorts of phone records oftentimes tell us about people's motivations, their planning, a variety of things that they are doing as a part of a criminal enterprise. We did not have that evidence previously. And finally, really in the last 15 years, the prominence of video, security and other sorts of surveillance videos that are really a part of our ordinary, common public lives is something that we didn't have in the 70s or the 80s or the 90s. These are the sorts of things which together, I think, make our cases better and leave us with fewer and fewer cases that are simply the stone-cold whodunit, where the only evidence you have is a person pointing to a photograph saying, "That's the guy, I'll never forget him." Something else has changed too. I think the attitude and approach of many prosecutors across the country, and certainly the prosecutors in the King County Prosecutor's Office, have shifted. I think we've watched the exoneration cases and we've become more attuned to and more educated about the phenomenon of honest but wrongful identifications, the issues surrounding memory, recall, and eyewitness identification, and we're able to sort of take that information and really bring it to bear in the way in which we make decisions. I think it's also true that many prosecutors will tell you that as you look at those cases that simply involve a single eyewitness identification with no other corroboration, there's probably a greater tendency to be conservative in bringing about criminal charges. That's not to say we can never do that. We must if we want to serve our community, but I think we do it conservatively and less often. The other area where we are now making strides is in the formation of a group called the Eyewitness Evidence Review Group in the King County Prosecutor's Office. That group has really been charged to work in two primary areas. It has been gathered together to sort of really review and look at the social science research that looks at not only at how eyewitnesses interact at the time of a crime, but also what sort of processes can be brought to bear as they go through identification processes to make their identifications as reliable and robust as possible. That group now is being brought together. It is reviewing the street research, it is talking to social scientists, and is sort of becoming a resource within our office as we decide how to and when to charge cases involving eyewitness identification evidence. The other critical job of this group will be to work with and to partner with our friends in law enforcement. The truth is there are a variety of things that we know right now that we can do in the field and which many, many police officers are doing, which can help us bring more reliable evidence into the courtroom. It begins with the instructions that we give to witnesses. When witnesses are told unequivocally, before an identification process, for instance, that the person who committed the crime may or may not be present, well, that instruction alone sort of gives people permission to say none of the above, and the result repeatedly in research is there are less false positives. Witnesses are less prone to make a choice that ultimately ends up being wrong. That's an important thing for us to pass on and to work with law enforcement on. The selection of other photographs. When you have a suspect and you want to have other photographs to show a witness to make it a fair test of their memory, the means and the manner by which you do that is important. And there are ways in which you can select those fillers, those other photographs, to make that a more fair and better test of memory for our witnesses. We need to work with law enforcement on that as well. The presentation of photographs, the means by which you do that, how they're presented, All of those things are things that we also can work with law enforcement to make sure that, first off, what the witness says is their memory and their memory alone, and isn't influenced by any other circumstance that's going on, and two, that it is the best memory test possible as they make a selection. The final thing that's important to us as we sort of review cases is documentation. Knowing what happened at the time of that identification, who was there, who was present, what was said, how long people took as they went through different parts of this process, what they said at the time of their identification, how certain they were at that moment, not subsequently, but how certain they were at that moment of the identification they made. Those things need to be fully and completely documented so that we're in a place to be able to review those cases and make sure that we're bringing forward the most reliable evidence possible. In 2013, the King County Prosecutor's Office presented an order asking for Brandon Olabar's immediate release from prison. We did that after thoroughly reviewing the case and after meeting with Mr. Olabar and interviewing him extensively. About a month after he was released, I offered to meet with him to explain our decision. He came with his lawyers and we spent about an hour together going through his case. What I explained to Mr. Olabar was this, that although the case had really been presented in terms of the affidavits that had been presented, that frankly that was not the evidence that the King County Prosecutor's Office found to be compelling. While it is not insignificant, affidavits that are given after a statute of limitations has passed, when there's really no consequence to anybody for saying that they were or were not involved in a robbery or who was or was not present, that was significant, but it really wasn't that compelling. But what we also looked at was, we looked at the original eyewitness identification again. And we consulted with experts and we looked at sort of analyses of how somebody might have made that identification. What we came to think could be at work in a case like that is this, that yes, the victim had picked Brandon Olabar, and that Brandon Olabar was likely to have been familiar to him. But was he familiar to him because he had been involved in the robbery? Or was he familiar because perhaps the two of them had seen each other on some other occasion, a social occasion between these families? Although the two did not know each other, there was evidence that they had been in each other's company at some point in time in the past. So we were opened up with a new prospect, that perhaps that would explain why somebody might pick Brandon Olabar's photograph as being familiar to them, irrespective of whether or not he had in fact committed the crime. The evidence that I found most compelling really was derived from the time that we spent with Mr. Olabar. Mr. Olabar described a variety of circumstances about what led up to that robbery, the home that he was living in, the sort of alibi that he in fact claimed to have had, the problems that he had had presenting that at the trial. We talked about the circumstance of being a person who believed he was wrongly accused and whether or not he had acted on that in a variety of communications with his lawyers at the time, his family members, other people. We also looked at the circumstances of his imprisonment. We looked at the way in which his sister had sort of tried to come to his aid at some point in time in 2006 or 7 to say that he wasn't involved. In all of that, from the time of his arrest, through his trial, through the time when this issue had first come up through his sister, and all the way into 2013, Mr. Olabar had been steadfast. He'd been steadfast that he was simply not present and that a mistake had been made. In combination with what else we knew about the case, that was deemed to be compelling. We ultimately offered that order to the court, and the court signed it, and Mr. Olabar was immediately released from prison. The upshot for our office is this. We have an obligation to look at those cases that come to us after the fact, where wrongful convictions have been claimed, and to analyze those cases fresh and anew, and to sort of apply what we know from social science and from other areas of our practice to determine whether or not, in fact, the evidence remains robust, reliable, the sort of thing upon which we believe convictions should be based. What we will not do is to simply defend convictions and not, again, reopen and look fairly at those cases that demanded our attention. But more important than that is the desire and the need for our office to be able to look at cases as they are first going through the system. We need to solve the wrongful conviction problem to the best of our ability before they happen. We need to apply the best science, the best social research, and the best minds in our office to look at these cases that are the true whodunits, and to make sure that we're comfortable as we go forward, that we're bringing forward the best, the most reliable, and the most robust evidence possible in those crucial cases. You know, throughout all of this, the Innocence Project Northwest have been real partners of the King County Prosecutor's Office. We've worked with them on a number of cases, and I suspect we will continue to do so. I will tell you though, through our evidence review group process, our goal should be and must be to put the Innocence Project out of business. There would be no more wrongful convictions. That may not happen, but that has to be our goal. Thank you very much.